So the main reason would be, why do we have meetings? And meetings enable shareholders, the owners of the company, to come and agree, have a consensus on what is to be done. It is in these meetings that they have directors, that they declare dividends and pass resolutions. And the two primary decision-making bodies, that is the general meeting of the shareholders and the board of directors. Again, because we said a company, one or two, so we need a consensus. We need to agree on the way forward. And the Companies Act places importance on the shareholders' meetings, and it has a considerable number of provisions regarding when and how they should be held. While the shareholders delegate the authority as members to the board of directors, that delegation does not negate the importance of them meeting and agreeing. Remember, in past classes, we have talked of special resolutions being passed. They cannot be passed by the directors. They are passed by shareholders. And when it comes to general meetings, between public and private, their features are distinct. And this is because of the sizes. So in a private company, the shareholders may know each other personally. And again, they may all have a position on the board. In public companies, however, the majority of the shareholders, there'll be financial institutions such as pension funds, and there'll be little or no contact between the shareholders themselves. As we have given examples earlier, I may be a shareholder, you may also be a shareholder, but we may not know each other. The only time we meet is when we are passing these, and again, we may not even meet, we may have proxies. So our guiding case for this is in Sharp versus Dawes, where a meeting of Coast Book Mining Company was summoned for the purpose of making a call, and it was attended by only one member, Silvers, Ides, and the secretary, who was not a member. The call was in due course made on a shareholder, Dawes, who refused to pay. The court held that the meeting was a nullity, and therefore the call was invalid. Kindly remember this case in the definition of what a meeting is. And we will have the exceptions to the case of Sharp versus Dawes, where the court will allow only one person. You see, in our definition, we are talking of a meeting consisting of more than two people. And this is the collective decision making in company law. It's not collective when it's an individual. It has to be two or more meeting, and that element of an odd number is to break a tie in case of voting. So we will have exceptions to this rule, whereby an individual is considered to be quorum. And this is where that one person will constitute the quorum, and it will be enough. And number one, if Section 131(2) of the Companies Act, it empowers the registrar on the application of any member to call or direct the calling of a general meeting where default is made in holding the general meeting as required by Section 131. So the registrar is empowered to give such directions as these things expedient, that one member present in person or by proxy shall be deemed to constitute a meeting. So the exception here is that where the company should have held an AGM, and the AGM was not done, you as the individual can petition, and the registrar will have constituted the quorum. Yourself, it will be enough to hold that meeting. Again, section 135(1) says that if it's an extraordinary general meeting and the act empowers the court, either out of its own motion or the application of any director or member of a company, to order a meeting to be called, held, and conducted in a manner as the court thinks fit, and where it will be impractical to call a meeting the old way. Again, at the discretion of the court, it will give directions as it thinks expedient, including that one member present in person or proxy shall be deemed to constitute a meeting. And for this, we have the East versus Bennett Brothers case, where it was held that a single person is enough quorum. And again, we talk of a class meeting pursuant to the provisions of the articles for the purposes of authorizing a variation of a right. And we also talk about if the meeting is adjourned, is an adjourned meeting, and the articles. We have a sample of the articles in the Companies Act, Article 54, Table A. And it provides that if within 1 hour of the time appointed for the meeting, the quorum is not present, it shall stand adjourned to the same day. And if at the adjourned meeting a quorum is not present, a member present shall form a quorum. We also have an exception of a creditor's meeting in a voluntary winding up of a creditor, and they're the only creditor. So that single creditor is enough quorum. He's seen to be, he's actually the only person in that meeting. And finally, for a director's meeting, and if the meeting is held by a sole director, pursuant to section 200 of the Act, in order to declare the nature of this interest in a proposed contract, and we have that whether the resolution passed in such a meeting is valid, the court holds that an effective extraordinary resolution will be passed. You see, he's the sole director, and it's a director's meeting. Again, the quorum is enough. That single person is quorum. So you remember, in Sharp versus Davies, a single person would not constitute a meeting, two or more, a meeting, a consensus. But in every rule, the exceptions. And these are the exceptions we have laid out. Section 131(2) of the Act, a meeting is extraordinary. Section 135(1), a class meeting and you're the only creditor. A director's meeting, you're the sole director. The provisions of Articles 54, Table A, about adjournment. You had a meeting, it was adjourned for the same day. And when the adjourned time came, it's only one member who was present. Again, is an exception to Sharp versus Davies. The single person present is enough quorum.